I'm going to call this meeting of the Oversight Committee for the date of October the 3rd to order. May we have a roll call, please?
Board members of Carrion.
Here.
Berry.
Here.
Nakasone.
Here.
Ochoa.
Here.
Sheehan.
Here.
Steger.
Here.
And Chair Raggio.
Here. And welcome to everyone in the audience. May we have a report of the Secretary, please?
The posting of the agenda for the October 3, 2012 regular meeting of the Glendale Oversight Board was posted on Friday, September 28, 2012 on the bulletin board outside City Hall.
Thank you. And the item 2?
There are no minutes for approval at this meeting, but the next item would be 3 for informational items. 3A is Director of Community Development regarding memorandum regarding Oversight Board roles and responsibilities, and this is a report only.
Good afternoon, Chair and board members. If I could just quickly touch on the minutes. The minutes for the special meeting you held on August 22nd will be included in your packet at next week's special meeting.
Thank you.
3A. At that special meeting, a couple of the board members asked for their roles and responsibilities as Oversight Board members, and specifically in light of AB 1484 passing a few months ago. Your legal counsel prepared a memo which was included in your packet, and I've asked them to do a brief presentation and take any questions from the board. At this time, I'll pass it on to Charles Green.
Well, brief. I'm a lawyer, so I'll try and be brief. I also brought another copy of our memo with me and left it on your blotters today, just so that you could have it for reference. I didn't realize it'd actually be in the package. Summarizing it, I'll start with the mission statement, what I would call a mission statement, which is that you have a fiduciary duty to both the holders of enforceable obligations and to the taxing entities. So it's kind of like representing two masters, but that is the obligation. As Oversight Board members, you're protected by the same immunities given to public entities and public employees, which is considerable. Unfortunately, you're not allowed to be paid any compensation or reimbursement of expenses. You must comply with the Brown Act and the Political Reform Act of 1974. We'll get into that in more detail later. It's my intention to provide you at no cost a summary, a very helpful summary of Brown Act obligations that we can give to public officials. So we'll be providing that to you later on. Addressing what your powers and duties are, though, which was the core of the inquiry. Many of the actions of the Successor Agency, which, as you know, is the city acting as the successor agency to the former redevelopment agency. Many of their actions must first be approved by this board. New repayment terms on obligations, except that the Oversight Board has no authority with respect to agreements between the successor agency and the county or city that formed it. Issuance of new bonds or pledges of property tax revenues, setting aside reserve funds, which is often required in bond documents, merging project areas, continuing to accept financial assistance in the form of federal or state grants, or assistance from private sources. And that applies if if there's a matching requirement that it exceeds 5%, the matching funds 5% of the grant. If the city wishes to retain any properties or other assets for future development, it must reach a compensation agreement with the other taxing entities, which you have to approve. It is your obligation to oversee the establishment of the ROPS. I know you're familiar with that process. Any request by the successor agency to enter into an agreement with the city of any sort has to be approved by you. Any request by the successor agency to pledge property tax revenues has to be approved by you. There's a process for due diligence review of unobligated balances available for transfer to taxing entities. Frankly, a lot of redevelopment agencies don't have such funds because they've obligated all of the funds in one way or another through bond pledges or whatever. But if that occurs in this situation, you have to approve or disapprove of the due diligence. There's also a long-range property plan, management plan, that must be adopted according to the statute, and it is your duty to approve the long-range plan proposed by the successor agency. When the successor agency has been issued a finding of completion by the Department of Finance, then the successor agency may seek to have agreements between the former RDA and the city deemed to be enforceable obligations. And your duty is to approve that if you find that the loan was for legitimate redevelopment purposes. There's going to be a lot of discussion between successor agencies and oversight boards on that issue because there's a lot of agreements between the former RDAs and their cities or counties that form them. You have to approve the administrative cost allowance. Of particular note, the Oversight Board has the right to approve or disapprove, or on its own, direct the successor agency to terminate an existing agreement or contract and to provide necessary or required compensation for remediation for such termination. In other words, you have the right to look at an agreement which the former RDAs entered into and direct that it be terminated, even though it's a contract, and you have the right to direct compensation to the other party as necessary for that termination. Ultimately, your obligation is to determine whether funds from asset sales and related funds are no longer needed for approved development projects and or to wind down the affairs of the successor agency. In addition, you have the right to direct the successor agency to do all of the following: dispose of assets and properties of the former RDA to be done expeditiously and in a manner aimed at maximizing value, or to transfer property for government purposes pursuant to existing agreements. You have the right to direct that they cease performing agreements and terminate existing agreements that are not enforceable obligations. You have the right to oversee and direct the transfer of housing assets. You have the right to terminate any agreement with a public entity where it's determined that doing so is in the best interest of the taxing entities. You may direct the successor agency to issue bonds or incur indebtedness, amend existing enforceable obligations related to another state entity's reimbursement payment of debt service on a bond. That's a little complicated, but basically it gets to where there is another public agency that has a debt reimbursement obligation under a bond. You have the right to amend that and oversee it. The only other thing that I think is noteworthy is that while you have all of those rights, all of your actions are overseen by the Department of Finance. And the Department of Finance can, despite what actions you may take, may find that they have an objection to them. The obligation of the Oversight Board is to provide by electronic means notice of any action which you intend to take, and those actions may not become final for 5 days after that notice is given, to provide the DOF with an opportunity to register a request for a review, which then begins a whole process, which I won't go into. But that ultimate oversight belongs with the DOF. So that's a summary of the materials which we provided to you. As you can see, you have a pretty broad power with regards to existing agreements, which the successor agency and/or the former redevelopment agency entered into or overseeing or managing. And with that power comes some responsibility for taking care that if you terminate agreements, that the other parties to those agreements are adequately compensated. So I think that over the years, over the time of whatever time we're going to be involved here, as you manage.
Do you have any idea what the time interval will be?
The law presently says that all of the oversight boards within a county are to be combined into one by 2016. It's going to be interesting to see how that works, or doesn't work.
Into one?
Into one.
And there are 77 of them at the present time in the county?
I don't know how many there are in the county.
I think there's close to that.
Like I said, it's going to be interesting to see how it works. And as I said earlier, this is one of the worst sets of statutes that in my, I won't even say how long, years of practice of law, I have ever seen. I've never seen such poorly thought out and structured statutes in my life. It's amazing. And it all changes from week to week, as we were discussing before the meeting began, Mr. Chairman.
Gary?
I have a question. It says accepting assistance from federal, state, or private parties. If, let's say, there's $1 million that the federal is going to give to the city of Glendale, what's our role in that? Do we decide where that money goes? Does that go into the general fund and gets then divided between the taxing entities? What happens to that money that comes, let's say, from the state that we accept?
You have no role with respect to the affairs of the city of Glendale, per se.
Okay.
If there's a grant to the city of Glendale, it does not involve this body. If there was a grant or a proposed grant to the redevelopment agency, former redevelopment agency, or the successor agency, then your oversight authority comes into play.
Okay, so if there is let's say if there's a grant, like, that's what I was talking about. Let's say if there's a grant coming to a redevelopment agency, or there's a contract that provides additional funds to the redevelopment agency from a private party, let's say, and that fund, let's say there's $500,000 that comes in. Who decides where that money goes or what happens to it?
Well, the successor agency decides, but then their actions are obviously subject to your oversight, just as yours are subject to the DOF. But the groundwork on all of this stuff is done by the successor agency staff. You know, they obviously prepare the ROPS, they prepare most of the material that has to be filed with the state. And this body's function is oversight in nature, although it does have the right to initiate actions, as I made the point.
That's what I'm asking. Let's say if the staff says we want $500,000 to go to, I don't know, something in the city, and this body decides, no, that $500,000 should go to this other project, even though you itemize it, the money hasn't been really allocated because we haven't approved it, but we want that money to go to something else. Would this body be able to then take that line item out, and because it's the funding that came in that wasn't allocated, it's being allocated by the staff, would we then be able to go ahead and allocate it for a different project?
Most likely, except that you have to face the fact that it's extremely unlikely, given what the state has done to redevelopment agencies, that anybody is going to be giving us grant money at this point in time.
I was really thinking about the former agreements that private parties have some funding coming in from private parties.
If it's an enforceable obligation, if that's been determined to be an enforceable obligation, then you would have to honor the agreement as to the allocation of money, unless you made the determination to terminate that agreement and pay the other side their compensation.
Can I ask a quick question on that point? Can you talk a little bit more about our obligation, our fiduciary duty to the taxing entities that we all represent recognizing that Mr. Berry and myself represent Glendale as a city and former agency, and the other side of those transactions. We have a fiduciary duty to the partners in those enforceable obligations. Talk a little bit more about what the balance there is.
That's the major challenge which is facing oversight boards, is because they've given you two fiduciary responsibilities which in many cases, many cases, are in opposition. So what do we do? I mean, as an oversight board, how do you resolve those issues? It's going to be a fact-based, individual determination by you, balancing the equities involved and the consequences in order to determine what you think is correct. If for example, terminating an agreement would generate the necessity to compensate the other party with X amount of money, but terminating it would create X times 3 in savings in terms of the money that the agency was obligated to put into the project, then you might balance those and say, you know, we have to determine what the compensation would be to the other party, which is not always easy. But you might look at that and say that's something we would be interested in looking at in terms of terminating the agreement and seeing if we can recover that money for the affected taxing entities as directed by the statute. But again, it's often difficult to determine exactly what the compensation would be. And one of the things that this leaves us in a position of is it's almost an invitation to litigation in many circumstances, which, you know, we absolutely do not want to be doing. So I think, you know, I've been giving this a lot of thought with respect to this board and to other clients, and I think that if, as a practical matter, if this body were to determine to terminate an agreement, I think that as a practical matter, it has to sit down and negotiate with the other party to the agreement. I'm assuming these agreements are enforceable obligations.
And understanding if there are no other circumstances that for those agreements being reached. And if there are some other issues that we can actually look into and those agreements were reached because of that, then there shouldn't be any negotiation. We need to investigate all of those issues.
Absolutely. I'm trying to give some examples of how you might have to approach things. I have a client, for example, that has been assembling land for 10 years for a downtown. And I think the argument there, and I'm going to be on the other side of the argument for that one, but the argument there would be that as the economy is slowly coming back, that land as a block is worth a whole lot more than parceling it off lot by lot. It costs a tremendous amount to acquire and clear, and a developer who wanted to build, you know, the kind of things that the city is looking for would undoubtedly pay a good deal more money for it than a whole series of small purchasers. So in that situation, you would look at it and say, well, in the short run, it might make sense to sell off the lots and take the money and hand it out. But in the long run, maybe that's not the best thing for the taxing entities, because, number one, they can sell the land for a good deal more when the right buyer walks in the door. And if they do, and if that right buyer builds a project of significance, then it's going to generate permanent long-term property tax to the benefit of the taxing entities. So it's all I can say is that each and every case is going to be a case of balancing so many factors that it's hard to even put them all in a box and say these are the factors you have to look at. I think that as each comes up, you'll hear, I'm sure, interested people in the community who want to see projects move forward for reasons which maybe do not relate directly to money. And you have to balance that against what your fiduciary obligations are to both the other party in the transaction and to the affected taxing entities. So it's going to be an interesting process, and I'm glad that you're the policy makers and I'm not.
I think for the benefit of the audience, we represent various entities up here. We represent the County of Los Angeles, the Unified School District of Glendale, the Glendale College, and the city. So consequently, the remnants of what redevelopment was had an obligation to each one of those entities, and we're here to see that those entities are in one way or another protected. So that's where part of the confusion comes about, too, is that we do have various responsibilities as board members, not only singly, but collectively as that.
Many of them inconsistent with each other.
Mr. Chair, if I might add something, and I think it's important, given the amendments that were made in 1484, and that has to do with that disposition of property by the Oversight Board in light of their authority to approve the termination or amendment of agreements. Now that we've got this new long-range asset management plan, the immediate disposition of property has been suspended until that long-range asset management plan is approved. So,
and we've been told it will be at least the spring of next year before they allow any kind of transfer of property.
That's correct, and that would be post the finding of completion. If once the agencies complete this due diligence review process, and you'll be looking at some of that today on the housing assets, and then are able to complete the other components which will enable the issuance of a finding of completion, only at that point will the Department of Finance commence consideration of the proposed long-range asset management plan. And it's at that point that the actual property dispositions will be considered. So that's something to take into consideration in the larger process of considering proposals for amendment of termination of agreements involving real property, at least.
Thank you. Any further questions? Now that we understand everything we're here for, we'll go on to the next item then. And
At
thank you.
3B is Director of Community Development regarding status of recognized obligation payment schedule for the period of January 2013 through June 2013. This is the ROPS 3, and this is a report only.
This item is to provide the Oversight Board with an update. As you recall, at your last meeting, you approved ROPS 3. We sent it over to the Department of Finance and other state and county agencies on the 24th of August. We received some inquiries from the Department of Finance on September 20th, and they wanted us to respond with justifications and additional documentation by September 26th. We did attach our response and the DOF's initial inquiry as part of exhibits to your staff report. At this point, we are waiting for the Department of Finance to issue their approval letter on the ROPS, and we anticipate that on Monday, October 8th. Depending on how that letter comes out, we may request a meet and confer if there's any items that we have a dispute with, or if there's no further inquiries, then we will accept their determination. But we wanted to provide the Oversight Board with an update on ROPS 3.
We can take care of that on the meeting of the 10th, then, can we not?
We have to get the agenda posted prior to Monday, so if anything, we'll provide another verbal update at the meeting next week.
Questions? Thank you. That doesn't require action at this time, does it? No. Next item.
At 4 is action items. 4A is Director of Community Development regarding receive and convene a public comment session on the due diligence review, DDR, for low and moderate income housing fund. At 4A1 is a resolution to receive and convene a public comment session on the due diligence review DDR for low and moderate income housing fund.
When AB 1484 passed, one of the requirements was that the agencies conduct a due diligence review, and you'll see the words DDR and agreed upon procedures AUP used interchangeably. DDR is in the legislation. However, from what we understand from the accountants, there is no such thing as a DDR. It's either an audit, which is a lot more detailed, or it's an agreed upon procedures, an AUP, which is what this is. But just so we can comply, we've used DDR and AUP interchangeably. And we are required to have 2 of these audits done, one on the housing side and one on the redevelopment side. Because if we go back, tax increment, 20% went to housing and 80% went to redevelopment. So what you have today is the audit or due diligence review on the housing funds, and you received an exhibit in your packet. The handout today is the fully bound copy, and I have asked the auditors to go over this with you, but essentially it's to review the low moderate income housing fund and then compare that against the obligations, enforceable obligations that were entered into prior to the Dissolution Act. If there's any excess balance, it gets distributed to the taxing entities that you all represent. So with that, I'll pass it on to Peter George of McGladrey to go over the DDR.
Thank you.
Do we need to open the public comment or just receive public comment? I don't know.
The statute requires that there be a public comment session associated with a review of the DDR, and it may be advisable at this time to open that public comment session with the acceptance of the report first as being part of that, and then inviting comments thereafter.
Thank you.
Good afternoon, members of the Oversight Board. Thank you, Elena. That was a pretty good intro. I am Peter George. I am a director with McGladrey LLP. We are the City of Glendale's external audit firm, and we also do a lot more for the City of Glendale as independent external accountants. We've been the city's external auditors for the last 5 years. This is our 5th year. And we were, and just to kind of touch on a bit what Charles was alluding to earlier, 1484 and AB 1X26 was kind of badly worded in the sense that it didn't give a lot of direction to some of the requirements that were asked for. So when this 1484 was put out a couple months ago, and everybody was scrambling to engage an accounting firm to do this independent, what they call this due diligence review, kind of the profession stepped back and said, well, there's really no such thing in the attestation standards, which is what this is, as a due diligence review. And attestation is something an independent accountant can perform on behalf of its client as an independent person or independent firm. So things like an audit is an attestation function, an agreed upon procedures is an attestation function, a review, a compilation, a financial forecast, a projection. There's all these different things that our profession has put out that we as independent accountants can perform on behalf of any client. But something called a due diligence review is kind of taking 2 different terms, due diligence reviews, and kind of putting them together to put some language, but it's really an ambiguous type of thing. Earlier on, when AB 1X26 came out, it required every successor agency to engage an accounting firm to do an agreed upon procedures audit. So another example of taking 2 different words and trying to come up with some kind of an opinion, which, again, the profession doesn't have a basis to provide. So what happened in this case was when this came out and everybody was trying to engage an accounting firm to do this particular procedure, we kind of had to push back and say, well, there's really no guidance. If you look at what 1484 asked for, it just basically said to provide any unencumbered cash balances to the proper taxing authorities as of June 30, 2012. Well, they gave about 6 things that they wanted to see, but they didn't really give direction on how they wanted to do it. When you call something a due diligence, I mean, it's as far as the parties want to go. Some parties can go way down to the bottom of the pool, so to speak. Some parties may just kind of skim the surface. It's just a matter of how deep does somebody want to dig. So, you know, kind of opened the Pandora's box, if you will, that some entities may go a lot further and incur a lot more costs. Some may not go far enough. You're going to have, you know, just in LA County, 77 different reports saying 77 different things. And there's about 400 up and down the state. So the state went back with the profession and came up with what they called suggested procedures. And this came out in, I think it was August 28th and put together what they call the suggested procedures, which is synonymous with, in our profession, agreed-upon procedures. So that's why when you look at our opinion, we tried to bridge that gap between this due diligence review language that you see in the actual standard and the actual law versus what we can provide as independent accountants, which is an agreed-upon procedures engagement. So the second paragraph of our opinion hopefully explains that bridge, but we believe meets the requirement to, to comply with the provisions of 1484. So having said that, basically everybody out there is going to be performing these sets of procedures in twofold. It's going to be one set for the low-income housing fund, which was due October 1st, and then a second set for the rest of the successor agency funds, which is not due until December 15th, 2012. So this was the first one we were engaged to do, and given that we had a short time frame to turn it around, we basically delivered the opinion that you guys got a couple days ago. And I'm sure have anybody had a chance to read it? Have any questions on it? But basically, we went through about 10 procedures that they suggested we perform. And I want to say that, typically when you have a bunch of folks putting together suggested procedures, since in this case they involved the profession from the very beginning, they didn't put things in here that could be ambiguous or inconsistent with agreed upon procedures. So things like verify something or determine the reasonableness of something. Those are not things we can do as independent accountants under an agreed upon procedures, because somebody's determination of reasonableness may not be somebody else's definition. So it has to be pretty much a concise set of procedures that they want the independent accountant to perform, which is, when you go through these procedures, is exactly what this is. So basically the way we outlined our report was, after going through the introduction and determining the responsibilities of the successor agency versus the responsibilities of your independent accountant, we go through and identify every one of the procedures we performed on behalf of the successor agency, and a results section, whether we noted any exceptions or we had any findings. And I want to report to this body that for the 10 that we performed, there was no exceptions to the procedures performed. There was no findings or anything other than that what we were engaged to do, we were able to do. And when you go to Exhibit F, which is basically the last exhibit on here, again, the purpose of this procedure was to determine if there was any excess unencumbered funds that should be remitted back to the taxing authorities. And based on the assets available for the low-income housing fund only, as of June 30th, there isn't any. So we're not expecting you're going to have to remit anything at this point.
Well, does that mean that we are through with this element?
That's what our understanding is, but then you're going to have a similar element, which is going to be a similar-looking report, but it's going to be for the other funds except for the low-income housing fund. And that's not due until December 15th.
Okay. And this was due the 1st of October?
It's just a couple days ago. Yes. But you should see the opinion dated on the fourth page, I believe, dated October 1st.
Who establishes these due dates?
This was actually, I think, in AB 1484, if I'm not mistaken.
Okay.
Did the state of California have an idea about what the amount of unencumbered funds throughout all the redevelopment agencies in the state, what that total would be when they first embarked on this?
From the reports I read, and don't hold me to this, but I believe it was somewhere in the neighborhood of $1.5 billion, but that was what I heard.
Based on what you're seeing now, I mean, do they have a more refined number as to what they hope to realize?
I haven't heard anything.
Charlie, have you heard anything? Microphone.
Ask you for your microphone.
I've heard anecdotally that it's going to be far less, but I haven't heard a number.
Mr. Chairman, Philip Lansfane, Executive Officer, Economic Development Asset Management. The Los Angeles Times reported on the 28th that they're expecting about $350 million.
From 1.7 billion?
1.7. I think the number has been coming down. At the last expectation, it was about $700,000 this year, so about half of what was expected.
So all of this was done for that amount of money?
Yes, sir.
Thank you, Phil.
Mr. Chair, I do want to acknowledge our finance staff, because as Mr. George indicated, the guidelines came out the 28th of August, and with McGladrey, they were able to put together an engagement letter, come out, do the field work, go over all the schedules that are required, and get it all done within the October 1st deadline. So I want to acknowledge our finance staff for working very hard to get this done so that we're in compliance.
I, for one, appreciate it, because just being a part of this organization for a couple, 3 months now, I understand what working backwards really is,
Right. Right.
and thank you. Is it time for the oral communications on this?
Thank you very much.
Do we have any cards?
No, we don't have any cards for this item.
You may want to ensure that the public comment component of this has been opened, and then if there are no communications and public comment on the agreed-upon procedure/DDR for the housing assets, then you may want to officially close the
Well,
public
is
comment
there
session.
anyone in the audience who would like to address this subject? And if you do, come forward and give us your name, and you'll have 3 minutes to express yourself. Seeing none, oral communications then is closed. Next item?
Okay, at 5 is oral communication. No cards were submitted, but in case someone wants to, discussion is limited to items within the jurisdiction of the Oversight Board. Each speaker is allowed 5 minutes. Members of the Oversight Board may question or respond to the speaker, but there will be no debate or decision. The matter may be referred to staff through the Executive Director of the Successor Agency for investigation and report.
Mr. Chair, before we go on, I would note in the agenda that there is a resolution that needs to be approved on 4A. So if we could back up from oral communications momentarily, now that you've closed that hearing, and consider that resolution for approval.
Would you take just a moment to describe the resolution?
The resolution is essentially to note that we did complete the DDR, get it over to the entities required by the October 1st deadline, and held a public comment session. That's the resolution for you today. You'll have another resolution next week, which would be to take the vote on it, which is also required. 5 days. The requirement of statute was that we wait 5 days between public comment and official vote.
Is there a motion to approve?
Motion to approve. Second. Staff's comment.
Any discussion? Seeing none, roll call, please.
No, sorry, who was the second? Board members of Carrion?
Yes.
Barry?
Yes.
Nakasone?
Yes.
Ochoa?
Yes.
Sheehan?
Yes.
Steger?
Yes.
Chair Raggio.
Yes. The motion is approved.
And then now back to oral communications. There were no cards submitted.
Again, is there anyone in the audience that would care to address any subject associated with the Oversight Committee at this time?
We actually have cards for the closed session, but none that were submitted for oral.
Seeing none, oral communications is closed.
Item 6 is board member staff comments.
Board members? It's kind of nice. We must be doing something right.
At item 7, we do have 6 cards for this item. Is closed session. 7A is conference with real property negotiator pursuant to Government Code Section 54956.8. Request made by General Counsel, property location 212 and 216 South Brand Boulevard. Property owner, City of Glendale, to be Successor Agency, negotiating properties, Oversight Board for the Glendale Successor Agency to the former Redevelopment Agency of the City of Glendale via General Counsel, and Museum of Neon Art, under negotiations, amendment, modification, or termination of lease.
Would it be appropriate for 3 minutes each?
That's at the discretion of the board.
I have 6 cards here, and you will have 3 minutes within which to state what your comments are going to be. And I need your name as you come up to the dais. J. Dupre, please.
Thank you, Mr. Chairman, members of the board. I'm here, my name is Jay Dupre. I'm legal counsel to the Museum of Neon Art. I'm here today to speak on behalf of the museum in support of the Glendale Successor Agency's to not terminate or cancel the lease. Specifically, I wanted to make sure that the board was aware that the lease is an enforceable obligation. The GSA would not be able to terminate or cancel the lease without a material breach, which would result in litigation, most likely resulting in the favor of the museum. So we just wanted to make sure that the board was aware of that in its considerations regarding whether or not to terminate or cancel the lease. That's all I have. Are there any questions for the board?
Questions? Thank you.
Thank you.
Kim Koga?
Good afternoon, Chair and Glendale Oversight Board. My name's Kim Koga. I'm the Executive Director of the Museum of Neon Art. I think I'm under 3 minutes here. I'm here today because I'm concerned about the Mona project and the continued commitment to the project by the Oversight Board. We began discussions and negotiations with the city in the fall of 2008, seeking a long-term home in Glendale. By spring of 2011, we signed the lease agreement. In June of 2011, we closed our doors on our temporary museum facility in downtown to focus on this transition. In the meantime, we have spent countless hours and tens of thousands of dollars in preparation and planning for the move to Glendale. As we get into a full fundraising mode, we will be spending tens of thousands of more dollars and many more hours. Mona's transition to Glendale is not just a physical move, but an expansion and transition from a small museum run by a handful of passionate volunteers into a small institutionalized museum, which will keep Mona and its mission of preserving neon as an art form alive for future generations to enjoy. We have invested all our time and manpower on this Glendale plan. There is no plan B in the works. All our eggs are in this basket. If the Oversight Board decides to terminate the existing project, this will put our organization in a precarious state. Despite the protections built into the signed lease agreement, any major change in plan will add additional years to Mona ever having a functioning museum facility. A museum must have a space and be open to the public to be considered eligible for funding. The longer our museum is closed, the more vague its future plans are, and the unknown date of our opening are all factors that will create hardship for our organization, for general membership, support, and for large major funding contributions. I urge you to not terminate the Mona project, but consider all of the above and the years of planning that went into this project, the concept of the cultural corridor created by the Alex Theater to the north and the Museum of Neon Art to the south, whose synergies will enrich the quality of life for the community of Glendale and for the entire LA region. Thank you.
Thank you, Ms. Koga. Rise Williams? Did I pronounce that correctly? Rise?
Reese.
Reese, all right. I'm sorry.
My name is Reese Williams. I'm speaking again on behalf of Mona. I've been a volunteer at Mona for a number of years now. In my professional life, I'm an instructor of glass blowing and glass history at various universities around the Southland. And I want to impress on the board members here today. You guys are talking money and fiduciary obligations and that type of thing. I think you really need to bear in mind the value of Museum of Neon Art to the city of Glendale and to the Los Angeles County. The history of neon is important. The first neon sign in the country was a Packard sign in Los Angeles, and I think we need to support that kind of thing and bring it on. Glendale's got a long history of supporting the automotive market down Brand Avenue with all of your car dealerships and stuff like that, and this will just enhance your history and be a nice bright spot on the avenue for people to come and visit. Thank you.
Thank you. Dave Quick?
Well, good afternoon, Mr. Chairman and committee. And I'm here in the capacity of an artist, Points Apparel. And I think I could kind of say I'm the institutional memory to a degree anyway, because I've actually been with Mona off and on for 30 years. And I was thinking about council informing you that within 4 years, I think you're all supposed to be merged out of existence. So, and Mona actually was on the board 30 years ago, and it's found a particular niche. And I think as you look at some of the not just fiduciary issues that are involved, but the cultural enhancement that it brings to the community, you're dealing with an institution that's shown a remarkable ability to survive. And in the 30 years that I've been in the arts, I've seen a lot of first-class gallery spaces and museums come and go. And here's Mona, really in its own way still going strong. Kim didn't mention they are currently, we're at the LA County Fairgrounds. They're part of the NHRA museum space. Mona is still there. Had thousands of visitors just over the last couple of weeks. So it has a real staying power. So whatever decision you make, I think you can be secure that the long-term benefit to the cultural corridor will be enhanced by Mona because of its track record. It's a 30-year-old institution looking for the next 30 years and looking to do that in Glendale. So, and good luck to you with your assignment. It sounds like you guys got something really going on. So, okay.
Thank you, Mr. Quick. Eric Links-Weiler.
Hello, my name's Eric Links-Weiler. I've been with the Museum of Neon Art for about 14 years. And it's just a drop in the bucket considering they've been around since 1981. Now, a lot of people, I've tried to explain the museum to them over the years. They think that the title is just signage, and I understand it's difficult for any city to embrace signage. I've worked with many with the Museum of Neon Art and the LA Conservancy, but the museum isn't just signs. The museum is science, it's electricity. The museum is an educational tool for kids, teaching them what the gases are and teaching them what that lightning in a bottle actually is. It's a wonderful way to get kids to interact and react, but it's also, yes, signage. A lot of people come to the Museum of Neon Art and seek it out specifically because they want to relive their roadside Americana youth. They look for those little neon signs, those pieces of our past. For example, the Museum of Neon Art has the Brown Derby from Hollywood and Vine. We've also got the Chinese Theater's neon dragons, which are about 30 feet long each. They're massive, they're beautiful, and people seek them out and want to be a part of it. So not only is it an educational tool for kids, it's also useful for tourism. Tourists flock to neon. Really, it's a moth to the flame kind of thing. And also, the museum has started already, even though we haven't opened doors. The Museum of Neon Art is actually doing neon cruises of Glendale. This Saturday is the museum's second tour of Neon Glendale. The first neon cruise completely sold out, busload full of people. We started at the Americana. This Saturday night, we're having another one, which is starting over by Zinke's in that cute little eatery with the neon burger joint. It's over there. And we're planning on doing another neon cruise in the future from Damon's, or another one from the Alex. We're actually already a part of Glendale, trying to be helpful to the businesses that are neighboring the future side of the Museum of Neon Art. We want to be a friend, and we want to be a part of Glendale. Thank you.
Thank you. Stuart Ziff.
Hello, Chairman and Oversight Board. My name is Stuart Ziff. I'm a neon artist. And I think one thought is, you go in a museum and it's empty. But I have an example of when it's not empty. We were set up at the National Hot Rod Museum during the county fair. And I have a sculpture that's activated by pushing a button. And I put a counter on it. They'd bring busloads of children in, I guess. So it's pushed 6,500 times in a month. And I'm gratified that my sculpture lasted that long. And it really brought a lot of joy to everyone. So it's a working museum. People come, and they're excited, and they see stuff. Thank you.
Thank you. I have no further cards.
Chair, I would like to submit 2 letters of support that were received by staff. I will hand them out. I made copies for the board. Linda Price and David Swenson. These are also in support of the Mona.
All right. Thank you.
If I may, too, we also received one, but we don't have enough copies, so we will scan it and email it to the board and staff.
Thank you. Yes.
Microphone.
Just a quick note. How many people in Mona are residents of Glendale? Okay, thank you.
Mr. Chair? If I may, and this is prior to your recess into the closed session for consideration of the item, that the Government Code Section 54.956.8 that governs closed sessions relative to real property negotiations limits those discussions to the price terms of the terms of a lease, the purchase, the sale, or exchange of real property, and the real property negotiators are to be identified. I would just note that for the record on behalf of the successor agency. Thank you.
Mr. Ochoa?
Really more a question, I guess, for Charlie. In terms of participation in the closed session, is that strictly this board or for?
I was actually going to ask the chair if I could address that issue. And I want to address the issue that council just raised, which is there is some confusion amongst practitioners of the law as to whether or not this board is even entitled to have closed sessions, because there is nothing in the statute that says it is. I have adopted the position, and obviously I have come down on the side of thinking that there should be closed sessions because I've asked for one. I've adopted the position that given the scope of your obligations and the fact that many of the discussions that you will have will involve a balancing of legal and financial issues and perhaps contain discussions of legal strategy, obligations, and so on, that it is essential that you be able to meet in closed session. I couple that with the fact that the statutes do specifically provide that you are subject to the Brown Act, which is where we find the authorization for closed sessions. So coupling those two things together, I have made the best determination that I can make under the law, which is not necessarily the one that the courts may adopt, but I think it's the logical, reasonable one that is in support of the public policy behind these statutes, that in fact you can meet in closed session, and that's why I've asked that you do so on this matter. It then brings up the second issue of who participates in a closed session. Typically, it would be the legislative body itself, which is this board, and their council, and then depending upon the nature of the item, people that are necessary or helpful in the discussion that are associated with, employed with, or agents of the legislative body. You are not allowed to bring in just an independent third party. For example, you cannot go into closed session with a developer or, for example, the one with Mona, and discuss in closed session with them the terms of the lease and so on. That's not permitted. It's only to allow you to have confidential discussions, which would be for the benefit of the public, so that you don't telegraph prices or strategy or other things. And so we are in a very unusual circumstance here. And that is that the staff, which is doing all of your work, does not actually work for you. They work for the successor agency and or the city of Glendale. The only people that I'm aware of that work directly for you is us. And so it raises a problem, because staff, typically the ones that have the most information that would be helpful to your deliberations, and a decision has to be made as to whether or not some or particular members of the staff should be admitted into the closed session. I believe, since there is an understanding that the successor agency is providing staff to you, that the better argument is that they are, in fact, your agents for that purpose. And for that reason, I would encourage you in this particular situation, and I'm not asking you to make a general rule here, because different circumstances may call for different decisions, but it seems appropriate to me in this particular situation to have counsel and Ms. Below in the closed session so that they can provide details which we probably are unaware of in the discussion. I would point out to them that the closed session privilege is going to apply here. The closed session privilege says that no one can discuss anything that was discussed in closed session unless this board waives that privilege, which it can only do by a majority vote. So people coming into the closed session have to recognize that they are bound by that privilege, and therefore it may place them in some kind of situation where they're not able to discuss things with their employers that they otherwise might have. It's a messy situation. But it seems to me that, one, you need to have closed sessions or you're not going to be able to do your job very well.
What you're saying is that they're unable to discuss this with the successor agency.
Unless you give them authorization.
All right.
Mr. Chair, members of the Oversight Board, and I think perhaps Mr. Green might want to weigh in on this factor as well, and that is that the basis for reviewing this agreement in the statute involves the not only a determination that was made by the successor agency and presented to the board for purposes of whether or not a particular agreement should be renegotiated or terminated, but also the exercise of the Oversight Board of its discretion concerning whether or not to agree to the early termination or amendment of the agreement. And this is what the statute says: if it finds that the amendment or termination would be in the best interest of the taxing entity, and so, there are findings that are required to be made, and I would submit that those findings would be required to be made in an open session of the Oversight Board. I don't know if Mr. Green has any different opinion.
I think that the findings and if there were to be a determination made as to what action to direct the successor agency to do, that's clearly a reportable action. It would have to be reported out in public. For reasons which we can discuss in closed session, I doubt that that's going to happen today, but if this board reaches a conclusion by a majority vote as to a particular course of action, then I don't see any way not to report it out, because the way that it is implemented is through your direction to the successor agency.
And that direction has to be public.
We have a very strong public policy in this state, as expressed in the Ralph M. Brown Act, of conducting government business in the open. It provides limited exceptions for that, to that. And the exceptions are primarily based around situations where it would not be in the public's interest to have those discussions in the public. For example, just a simple example, if a legislative body is contemplating acquiring a piece of property and they're meeting with their staff to tell them how much to offer and how much, what their bottom line is, you offer them $500,000, but you can go up to $7. Obviously, that's not something you could hold in public, because you just telegraphed it to the other side. You're going to be paying $7 no matter what. So there are certain exceptions for labor relations, for real property, for potential litigation, for threatened litigation, and so on, where there are exceptions carved out to allow you to meet in closed session. Because of the direction we were given to analyze the Mona lease, and because of the necessity of addressing certain legal strategies in doing that, I don't believe it could possibly be discussed in public without revealing information that, should you make certain decisions, would be adverse to the public interest.
Well, I think for the benefit of those people who attended, there would be no discussion after the meeting today.
Well, I have to disagree. If in fact, what has to happen is this body needs to reconvene an open session after the closed session, and an announcement needs to be made of any reportable action, or if there is no reportable action, an announcement needs to be made to that effect, so that the public understands what has transpired. So we would reconvene an open session after the closed session. But I felt it necessary to tell you that there's some argument out there that oversight boards don't have the right to be in closed session. I disagree with that theory, and I think it is contrary to the public policy behind these statutes, however twisted that public policy may be. And therefore, that's my legal conclusion, and it's the best advice I can give you today.
Well, thank you. I'd hate to be put in the awkward position of having something safe and secure with respect to what our actions are going to be.
I know, it would be terrible, wouldn't it?
Yes.
Mr. Chair, if I may make a recommendation, in order for you to have a more helpful closed session, I'd like to ask Mr. Lanzafame to either also join, or for me to, for him to be the substitute, as he's got more background and knowledge with respect to the closed session item.
Actually, I might even go one step farther than that. I mean, to the extent that if this board were to terminate correct me if I'm wrong, if we were to terminate the lease, the successor agency has to undertake whatever settlement, whatever negotiations that might be, in terms of the damages to make good faith as best we can.
Well, ultimately, yes, because this body is not actually, this is another one of the arguments about the real estate exceptions to the closed session. This body is not actually a party to the lease, but my feeling is that because you have been given statutory authority to require termination or amendment or whatever, that it places you in a position that it effectively makes you a party. So,
Well, to the extent that the city and the successor agency is represented by Mr. Garcia, who's the city attorney, Mr. Pagani, who is the CDD director, it would seem to me that they have to be party to whatever the discussion is that we have, either sitting in closed session or being able to divulge information to them if they are indeed, if we truly are going to give an objective, blue sky look at this to see if really we want to move forward or not move forward. Either one of those two gentlemen is going to have to play a role at some point if we move forward with termination.
Or I might add, there would have to be a waiver.
Oh, or a waiver.
That would be the other option, and to allow us to have further communications with representatives of the city and other members of the successor agency.
as I said, I'm not asking you to make a hard and fast rule here, because I think the circumstances will change perhaps from situation to situation. The one thing that I do have to tell you is that the city's interests and this board's interests are not always in alignment. And I don't have any objection to the proposed people to attend this closed session. We're feeling our way into these kinds of things, and we'll learn as we go along how it works, but I think that the inclusion of these people, as all mentioned, all of the above, is probably appropriate for this.
Well, I would prefer that we rule on the side of getting too much information as opposed to getting too little. And
Mr. Chair, yeah, I agree with you. I think if you're going to make a decision, we need to know the background for the decision, and the background from the decision comes from an entity that's no longer here and from the people that were there. So the more the merrier, so to speak. If they're not in there for the whole session even, at least they need to be there to give us the background. as to
it
what we
sounds
need to
like
know.
we need their input in order to make a decision.
Mr. Chair, would it be possible to take sort of a staggered approach? In other words, if we, I would like it if we could have a smaller closed session to have a discussion and then bring people in as we need them. Would that be possible?
Yes, that's
Agree.
possible.
Okay, so it's on call, and to a certain extent for certain people?
Yes, if that's the pleasure.
Respectfully, I would disagree. And just in terms of, you bring people in at different parts of the story, sometimes the continuity of the narrative, the context is compromised. If folks have information, I think we need to have as much information as possible at the same time. I think we're relying on the ethical tenets, both the city attorney as well as the other staff, to make sure that which is said in this closed session is maintained in this closed session. To bring them in and out interchangeable pieces, I think, does not give us the highest level of information, accurate information.
The one disadvantage that we have as general counsel is because you select general counsel who hasn't represented any of the entities, is we do not have depth and background in these transactions. That's by the very nature of people that you go out and seek to hire. So I would agree that in a transaction of this sort, which has a lot of ramifications, I think that having that information available to you is probably essential.
Mr. Steiger, if I make a suggestion, if instead of meeting first and then bringing people, why don't we have everyone come in, give their story, give their information, and then we can meet on a smaller group and then have a discussion at that point.
That's
After we get the information that we need, then we'll meet on a smaller group.
totally within your control.
Now, who are we talking about coming in with us?
Well, Mr. Lansafame, the city attorney, I think we're and
Mr. Hagani is.
Ms. Bavolian, I
Srigani?
don't see any reason for her not to come in as well. Now, there's one other issue.
Brittany, would you like to come in too?
Of course, there's only one other issue. There is a procedure under closed sessions which is optional to the individual body, and that is whether or not minutes are kept of the closed session. Many bodies do like to keep minutes, and they have city clerks attend for that purpose and so on. Many others do not, because under certain circumstances, those minutes have to be made public. And those bodies feel that it might deter a frank and open discussion of the various factors if there were a permanent record that could somehow be made public.
Might we direct Ms. Bavolian to keep action minutes only of whatever action was taken, as opposed to the play-by-play?
Well, if there's any action taken that's reportable, we're going to report it out exactly what it is. So I'm merely expressing that there's an option here. I have a mild preference for not having minutes kept because I have seen them come up in litigation. And in one instance, to the great detriment of the city that was involved. But on the other hand, it's a mild preference. So I leave it to the board to decide whether you want to have that permanent record.
It's the pleasure of the board.
I would prefer no minutes.
Concur.
Is that a consensus? All right. We get no minutes. Action items only. And are we ready to go? Have we?
Mr. Chair, members of the board, your action would be to recess into closed session.
All right. And that's just exactly what we'll do. We'll recess to closed session.
And for the public's benefit, we will reconvene in public, and if there's a reportable action, that will be reported at that time.
Call the meeting to order. We're back from our recess, and no reportable action was taken. This has been extended to the October 10th meeting, which takes place at 2:30 next week, and we will have a closed session at that time regarding the subject. New business?
Second.
We are adjourned. Thank you all again.